Almost there, Kelly.
All
right. Okay, I think you can get going.
Well, thank you so much, Angela. Welcome, everybody. Welcome back to Bar Talk. It has been 5 months, 6 months since we last held Bar Talk. I'm delighted to get Bar Talk in its new incarnation started again. We're delighted to have the Chief Justice here to kick off this new season of Bar Talk. It sounds like a TV show. Trust me, it's going to be much better than any TV show. So just as so I'm Kelly McDonald. I'm the current president of the Maine State Bar Association. We've got Angela Armstrong making sure everything goes smoothly. Angela is the executive director of the association. I want to just give you a quick update on Bar Talk. As you may recall, when Thad Day was the president, when the pandemic hit, he and Angela put Bar Talk into place, which was a, if you can believe it, daily online update of what was going on. Things were moving so quickly back in March and April of 2020 that there was a lot of information flying around. After a couple of months of the daily updates, we scaled that back to weekly. Last spring, we hit pause for the summer. Attendance was declining. It was becoming, it felt like it was, there wasn't enough information to make it worthwhile to be holding it on a weekly basis. So we took a break from Bar Talk for the summer, spent some time thinking about it and talking to people. We got a lot of great feedback from folks who said that they really appreciated the opportunity to hear directly from the association, from the judicial branch, and from other speakers. And so what we have decided to do for the foreseeable future is to maintain Bar Talk. We're going to hold it on a monthly basis at 11 o'clock for a half an hour or 45 minutes as events warrant. And it's going to take place on the Wednesday of the second full week of the month. And the reason for that unusual scheduling is so that it lines up with the law court oral argument schedule, so that when the Chief Justice is available to join us, our schedules align. So the slide that Angela's put up on the screen has the next couple of Bar Talks, or the next one Bar Talk, November 10th, on it. And so it will be on a monthly basis. If you have information that you would like to be seen on Bar Talk, speakers that you would like to hear from, and so on, please let myself or Angela know, and we'll try to make it work. So that's Bar Talk. Welcome back. I want to move past all the procedural matters and get to what we really want to hear. I know that you're not actually here to listen to me. It's okay. You are here to listen to Chief Justice Valerie Stanfill, making her first appearance on Bar Talk. Thank you so much for being here with us today, Chief Justice.
Thank you. You're making it sound far more exciting than I think it really is.
No, I'm excited. As you all know, the Chief has recently been appointed to the law court. Prior to that, she served as judge on both Maine's District Court and Superior Courts. She's taken on this role in the middle of a pandemic. I had the pleasure of meeting with the Chief in, what was it, maybe a month and a half ago. And we talked a lot about the challenges of taking on this role in the middle of the pandemic. So we've asked the Chief to join us to give us an update on where things stand with the judicial branch. Obviously, we are still in the middle of the pandemic. Obviously, things are not back to normal. They're not going to be back to normal for a while, if ever. But that said, life goes on. Lawsuits happen. Crimes are committed. The legal system has to continue operating somehow. And I think that what we all are excited to hear and participate in is trying to get that judicial system back to fully operating capacity. So with that said, thank you so much for being here. And I'm going to turn the floor over to you.
Thank you, Kelly. I don't promise to be better than a TV show. I think you made that promise at the beginning, and I don't promise that. But I would like to at least spend a few minutes talking about what the challenges are facing the court system and access to justice, which are at this point really pandemic related in a very broad sense. As you know, we had a great deal of hope and optimism last spring. In fact, when I was originally nominated at the beginning of May, I thought, this is great. I'm going to come in at a time when we're really coming out of the pandemic. We'll be able to be very forward looking. Boy, was I wrong. So as it turns out, as everybody knows, after a little bit of a lull in the summer, things came back with a vengeance. And so we are really at this point having to adapt to what I would call a new normal. The current status of specific COVID protocols is we still have in place what we called the PPMO. We had a recent administrative order that I think was part of the screen that Angela put up regarding remote proceedings. You will note that that was not strictly pandemic related, although that certainly is one of the reasons for doing it. It's not the only reason. And that administrative order is intended to be in place really until further notice, not necessarily only for the pandemic, regarding certain proceedings being remote. In addition, right now, because of high transmission rates in the state, internally, we are taking even additional precautions for smaller dockets and even more remote proceedings as appropriate, just to try to keep the health and safety of everybody in mind. Those, depending on what happens with rates, that's an inward facing, if you will, policy, depending on what happens with transmission rates and the like in the state, that can change week to week. But the administrative order does not change regarding remote proceedings and asking for certain proceedings to be at least presumptively remote. That's actually one of the good things in some ways that came out of this whole pandemic, was the ability that we're all very comfortable with doing the Brady Bunch Zooms and as well to how to handle these remote proceedings, what are the protocols and the like. The court invested in under the leadership of Justice Mead, invested in the Zoom carts and the technology to be able to accomplish that. As a result, we did keep up on some dockets, some better than others, as you know, during the pandemic. However, there are obviously significant backlogs, particularly when it comes to criminal and civil jury. Before I talk about the dockets individually specifically, I'm going to mention there are some overarching problems that we face in trying to get caught up on these backlogs. The primary one really being staffing and recruitment. The legislature did approve some additional marshal positions last session, which we have been actively recruiting for. And I have to tell you, in many parts of the state, we have been thus far unable to fill those positions, consistent with, frankly, what's happening in law enforcement and corrections across the state. Some of you I know are very familiar with what's going on in some of the jails and some of the police departments. We did raise the pay a little bit. So we got some additional positions, and we're still working on it. And I'm hopeful that we'll get there. The importance of that is that that really is an important piece of being able to hold things like jury trials. We need jury officers. We need to have the marshals staffing that, and jury trials in particular take more marshal resources. We're also suffering a bit on clerks Megan, I see nodding her head. Certainly in Kennebec, the turnover in the criminal department of the clerk's offices has been very significant. And that's a problematic too. Again, every restaurant has a, help wanted sign in their window. This is nothing unique to the judicial branch, but it is a problem for us. And frankly, judges, we currently have 3 open slots on the district court, 1 on the superior court. Within a couple of months, it's going to be 5 open on the district court and 2 on the superior court. Given our numbers, that's significant. So hopefully, the governor will act quickly to fill some of these positions. But all of these things make it obviously much more difficult. This is a judicial branch, and I think I was aware of this when I was a trial judge, but now as chief, it is just writ large. This is a judicial branch that was really operating at capacity before the pandemic. And so, as you can imagine, that makes it extraordinarily difficult to try to not only do what we were doing before, but to do even more at the same time. I look at the last few months and currently as being almost a period of assessment, frankly, to see now that we are back to some of these operations, where are we really? How much of the backlog will sort of quickly disappear if people just simply get scheduled, things like that. But it's not going to all disappear because cases get scheduled. Not every criminal case is going to result in a plea. Not every civil case that gets settled that gets scheduled is going to settle. So that's not a plan, obviously, to deal with the backlog. To be specific, in civil jury, I know that that's been a big problem. Obviously, we didn't have civil juries for a long time during the pandemic, if at all, actually. There were a couple scheduled earlier this year that got called in. None happened because, for a variety of reasons, as is often the case, they decided not to have a trial at that point, but a few were called in. We have some more that will be scheduled in November, and in every county, there will be at least a limited civil jury list within the next few months. Certainly, I would say by the end of February. Some counties don't have them every month anyway, so certainly by the end of February. That will help with, I think, some of the smaller cases. It will not help necessarily with some of the bigger cases, the medical malpractice cases and the like, that really need more special assignment and take more resources. So one of the things we're doing is we have a committee that's headed by Justice Horton. And I know there's some members of the bar that are assisting in that. And I've asked them to really push forward. I know that they'll be doing meetings with the Superior Court during administrative week after next, to do some real statewide planning on the, rather than leaving it to county by county to get civil juries scheduled. We may need to do almost like a supernumerary kind of thing to get some of the big cases scheduled on, and look at those schedules on a statewide basis, just as we do with things like murder cases in the criminal arena. Which is a whole nother topic. They're going to be looking at the remote jury trials, hopefully getting some of that started, as well as maybe doing some triage and conferencing in some of the civil cases to really sort through where we are on these cases. The raw numbers on cases ready for civil jury are fairly small. I mean, in the biggest counties, it's less than 50. But obviously, it's still a significant use of resources in order to get through those cases. Criminal, well, the pending case numbers, we currently have 26 as of earlier this week. We have 26,740 pending criminal and VI cases. That is a 49% increase over the same date 2 years ago, pre-pandemic, essentially half again as many. That's a lot of cases. The good news is it's actually a little lower than it was a few weeks ago. And in fact, it's the lowest number of pending cases in at least the last 6 months. So I'm hoping that may be indicative of a bit of a trend down. I would say 2 weeks ago on my last report, we had a 55% increase. Now we're at a 49% increase over 2 years ago. So that, I'm hoping, fingers crossed, is a trend that's going to continue. We are scheduling, we have been going, I would say, full bore, if you will, on criminal in every county, the most we can. And that's part of the reason why civil has been such a backseat. So where do we go? How do we fix this? Well, if you have brilliant ideas, please send them to me on the screen that Angela had, and I'm going to repeat it. There is still an email, courts post-COVID planning comments, all written together. Courts post-COVID planning comments at courts.maine.gov. And we've heard lots of complaints, when are you going to do this and how are we going to do this? But I would love some solutions too. I mean, I don't mind hearing the complaints, but, solutions would be very welcome. A few things that we are doing that I think are helpful. One, as I've said, the committee is going to look at scheduling differently than we have in the past, maybe for things like civil jury, and doing it more on a statewide basis to try to be very intentional about how we get these in. Similarly, we do that with murder cases, and we're trying to get those in. And partially, these are large cases that take a lot of resources and often involve the same attorneys as well. So, it's helpful to get them in. The use of remote, that's part of the reason, obviously, for that administrative order. And that's a savings. It has good and bad things about it. It's a savings from the court, also on things like marshal resources, to the extent a proceeding or a docket is fully remote. We don't need a marshal, which is very helpful in order to get some of the other dockets scheduled. It can obviously save attorney time, save money for your clients, both civil and criminal resources, the travel for litigants, who have a hard time traveling to court, taking time off for court and the like. There are some negatives about doing things remotely, aside from just the general issue of having a trial or a hearing remotely, but there is significant burden on the clerks. For example, with remote mediations, under the old system with mediations in family cases, when the clerk would schedule a mediation, she put the date into the computer system, it spit out a notice, and they mail it to the parties, right? Now she has to scan, she has to undo the entire file. And in FM cases, those files, as you know, can get quite large. And take every staple out, all that, undo the file, copy and scan the entire file to the mediator. And then also, when it comes to doing the notices, she can't just do it in the computer. You have to make a Zoom link. You have to manually, physically write on each of the person's notices what the Zoom link is, make sure we have an email for everybody, which of course is not necessarily part of what comes in, et cetera. So it does, they're all little tasks, but it has changed. I mean, I would talk to a clerk. I mean, scheduling a mediation has changed from, a 1 or 2 minute process to a 20 or 25 minute process, times how many mediations do we do? So that's just an example of the problem. Some of the problems, the lack of internet access, frankly, the protocols for self-represented people. I mean, I'm sure the stories are legion, of course, and some of the funny but not so funny things that happen during these Zoom hearings. And sometimes even as simple as afterwards, we've literally had people go, okay, that was great. So when's my day in court? I mean, they don't understand that this was their day in court. So there's problems with doing things remotely, but it's certainly a tool that we should use going forward. And it can be helpful in that respect. One of the things that we're also looking at, and I'd be interested in reactions to this, is asking for is to fund from the court's perspective the use of referees, using retired judges, not active retired judges. In other words, judges who are no longer on the bench, using some retired judges primarily as referees in FM cases and potentially civil non-jury as well. At the expense of the court, that the court would pay the referees, which in FM cases, referees are frequently used for larger money cases, for complicated cases, if the parties can afford to hire them. But in most cases, or in many cases, they really can't afford to hire them. So if we could pay the referees from the judicial branch, use people who were judges, who did this kind of work, who sat on these cases. We're hopeful that that may help us as well to free up some judicial resources, again, to put in the places where we really can't do that. We can't do that in a criminal jury, obviously. But we're looking into doing that in, as I say, primarily FM, but also civil non-jury. And frankly, we're going to have to look at, I think in the long term, we really do have to look at the structure and the funding of our court system in this state. We have traditionally in the judicial branch been the poor stepchild of the branches of government. We have, fewer judges per population than almost every state, et cetera, et cetera. And I think that the stresses of the pandemic have really highlighted just how little room there is there. When I was still on the district court, for example, the last several years I was on the district court, we were told we could no longer have writing days. I mean, that sounds like a little thing, but we all do our own writing, it's have laptop will travel. Our trial judges do it themselves. And to say that you don't get a day to do that, when do you actually write those decisions in those FM cases and civil cases? Well, it becomes kind of, hopefully maybe something settles. And it's basically nights and weekends. And so that's really not the way. How is there then capacity, to do more? I think we've already asked our system to do an awful lot. So in the long term and in the big picture, I think that's something we have to look at as well. So that's basically a quick snapshot, a little romp, I think, on where we are in this pandemic. I thought coming in, like I say, I was going to be able to be much more big picture, where do we go? This is great. And clearly dealing with these pandemic issues is going to be our future for a while. So with that, Kelly, if you or anyone else has some questions, I'd be happy to entertain them.
Well, thank you so much. I really appreciated that thorough overview. Anybody who does have questions for the chief, feel free to either leave them in the chat, or if you would like to anonymize your questions, which is fine, email them to Angela. Sorry, Angela. And Angela's email address is aarmstrong@mainbar.org. So again, feel free to leave your questions in chat or email them to Angela, and we'll get them. We'll make sure that we have a chance to address some of them. We did receive a couple of questions in advance of our session. And the questions that we received were primarily about the things you're talking about how to restart trials and so on. We did get one question, which is if civil jury trials aren't imminent, if it's looking like it's going to still be months before we are able to really get back into the pattern of things there, does the judicial branch have proposals that they could make to the legislature to address that delay? So some of the examples that were given were increasing the rate of prejudgment interest, holding more judicial settlement conferences, providing for a plaintiff's offer of judgment. So in other words, if we can't do civil jury trials right away, are there plans for proposals to the legislature for statutory or rule changes that might help address that delay?
Well, thank you. I mean, first of all, I do think there is plan to get them underway, although perhaps not as rapidly as people would like. Some of those ideas have to be, as you said, addressed to the legislature. Something like changing a prejudgment interest rate is really not something for the judicial branch to propose or to advocate for. That is something outside of our purview. Offers of judgment are in the civil rules. If people think that needs to be amended, or even in the short term or long term, a proposal can be made. That is not something we are talking about internally. Now I can't remember what the third thing was that you mentioned. There was a third thing.
Judicial settlement conferences.
Oh, well, they're available, and we would be happy to facilitate as many judicial settlement conferences. If anybody wants one, please make that request either to the court where it's pending, or to the chief of the court. I think it's we have a person, I think it's based in York County. It's no longer Colleen Heel. I think she managed to farm that out to someone else, but to one of our new hires in York County, but somebody who is in charge of setting those judicial settlement conferences. And that's one of the wonderful things about Zoom is we could do them that way and therefore use, a judge based in Portland to do a judicial settlement conference from Aroostook County without having to worry about the travel, and even to do, you know, one from Aroostook in the morning and one from Oxford in the afternoon. So absolutely, you know, we want to be able to use what resources we have, particularly with the active retired folks, and to do judicial settlement conferences as much as we can. So if people have civil cases that they think might be amenable to that, please make the request. We'd be happy to try to accommodate it as best we can.
That's great. And I will say that as someone who has done a lot of mediations and JSCs over Zoom, I actually find the format to be great. I find it to be very effective because during that hour when you're sitting and waiting for the mediator to come back, you can actually do other stuff.
Right, absolutely.
Waiting. So I find it to be very productive. Here's a question. Dispositional conferences were the hallmark of the UCD. Now I'm just going to read this because I have no idea what I'm saying. Now that they have been discontinued in many counties, including Kennebec and Cumberland, is there any thought to either returning to the criminal system before the UCD or looking at other states to adopt a new system?
Short answer is yes. I think right now, I'm not sure. I think the idea of suspending dispositional conferences in a few of the counties was really to try to turn judicial resources to other matters. One of the problems that has always been true in our system, and one of the reasons I think that was the genesis for the UCD some years ago, was that it was, we'd end up with all these cases where no one had ever talked, right? And they get put on a trial list, and you knew that this trial list of 100 cases was really at most one trial, because, you know, on the day of the docket call, everybody says, oh, we're talking. So the idea of the dispositional conferences in criminal cases was to, you know, put in a piece that sort of required parties to come to the table and talk. The problem is it is a heavy use of judicial resources. I mean, you're having a conference in every single case with a judge. And as is often the case, when we put in a procedure like that, it also has a tendency to affect behavior of counsel. And so the attorneys who would have talked before now don't necessarily talk until they come to their dispositional conference. So it becomes a little bit of a, you know, a self-fulfilling. I mean, that varies obviously quite a bit with, you know, attorneys across the state. But there's no immediate plan to change things, but I have asked the Criminal Rules Committee to take a look about whether there is a better system. There has to be a process, something between the, you know, arraignments or initial appearances and trial lists. Okay, there has to be something in between, or the system would fall of its own weight. But what is that? And for example, in Massachusetts, they, I think, use the parties are required to report to the court on a form that both the district attorney's office and the defense counsel have to sign off on, that they've covered all these different things, including, you know, settlement discussions, but also, is there a need for, you know, just exhausting discovery issues, et cetera, et cetera. That's a possibility. So, I mean, I agree that we need to do something. You know, I think that, and I'm not sure, I look at this as an experiment in some of the counties, and I'm not sure how it's going in terms of not holding dispositional conferences, but that really is at this point a temporary measure just to try to get caught up. In Kennebec, for example, there were so many days devoted to dispositional conferences that motions that needed a hearing couldn't get heard, et cetera, et cetera. So it's an effort to try to at least get some of the cases that are ready to move through the system, get them moving through the system. So again, if people have bright ideas on a system that they think would accomplish these different goals, I don't think there's any thought of not having a unified system, of going back to where we were per se. But, you know, I think that we may need to treat self-represented cases differently, et cetera, et cetera. So we're interested if you have ideas.
And because everybody's lawyers, I'm sure they do have ideas. So that the next question has to do with how we can make our voices heard. So you've offered up the email address, and we'll put that in the chat. You guys are going to see that again on our slide in just a minute or two. In addition to sending those emails off into the ether, would it be helpful, would the judicial branch be interested in more participation and in some format by the bar, whether it be participation in working groups, and you mentioned the one led by Justice Fortin, or part of our winter bar conference, for example? Are there, because I know that the experiences of practitioners, I know there are a lot of practitioners who have expressed to me that they have ideas, they want to see the judicial branch doing the right thing, and sometimes there is a perception that those thoughts are not being received or not being taken into consideration. So in terms of bringing about more conversation between the bar and the bench, any ideas from your perspective about how we can kind of cultivate that conversation?
Sure, all of the above. If you want a conversation at whether the winter bar meeting or at other times, we would love to have them. I personally, want to hear from people if there are ideas or concerns. That's why we also have that email about the post-COVID. It's a little hard to deal with it individually. It's a little more helpful if there are maybe groups or something like that want to, but I'm happy to talk with people. That's why I met with you, Kelly. I've taken the opportunity to meet with I think about 2 weeks ago, met with the Maine Trial Lawyers Board, and had a conversation. I've met with the Maine Bar Foundation, had a conversation. I've met with the legal services providers, had a conversation. I have ongoing conversations with the folks at the Maine Indigent Legal Services Commission. So I'm trying to, for exactly those reasons, I would love to have those channels be open. And so I'm open to being included in some of those conversations as well. And, if you talk to your chiefs, the trial chiefs, or to the court directly, that's fine too.
Fantastic. Thank you. Here's a question about motions for remote appearance by counsel. Does the court plan to amend rules for consideration of such motions? And if so, could consideration be given to the travel time and costs for the attorney to appear, the cost of litigation overall, and whether the attorney is providing services pro bono?
Sure. I mean, I think that's part of the purpose of the administrative order that went into effect a couple of weeks ago. And that's why it was not done as simply a pandemic order, but rather as a standing administrative order. I think in the preamble specifically notes that it was an effort to try to conserve resources to make it more affordable, whether for legal services, for indigent legal services, or for just attorneys in general, to help in these cases. And it lays out, I think, the procedure and protocol, which proceedings will be presumptively remote, and requests to have additional proceedings be remote as well. I'm certainly encouraging the bench, and they've, I think, gotten that message loud and clear in recent weeks for sure, to encourage remote proceedings whenever we can do that, consistent with due process and the other issues that we do have to think about occasionally in the court system.
Yes. We have a question about, looks like this relates to family law cases, having to do with the fact that a lot of family cases are being docketed as backups to the PC docket.
Thank you.
And hi, Mike, you're not on mute.
He is now.
And a suggestion, would the court consider modifying the 7-day deadline to file exhibits for remote hearings to a shorter span of time, say 48 hours? Because I take it from this question, a lot of times there's you're getting called, you're submitting the documents, there's rarely 7 days notice before the dockets get called, and then they are backup calls, and the cases don't end up getting heard. So kind of a suggestion about that procedure.
So that's going to vary a lot county to county. So the larger counties do have separate PC and FM dockets. It's like, for example, in Portland, the smaller counties have combined. Obviously, if it's backup, that's a problem. You usually would get more notice than that of the list. And I would think if you wish to have it heard remotely, that we might do that at that point, whether or not you're called in as a backup case. I would suggest talking that over with the judge who is primarily in charge of the list in terms of how they want that handled, whether you file it essentially when you get put on a list saying, if I get called in, we would like to be heard remotely or not. I mean, I think we'd rather know ahead of time too, honestly. And rather than calling in at the last minute and then having somebody say, let's hear it remotely. I understand it may vary depending on when you get called in or if you get called in. But that's another reason why we are talking about doing potential referrals to FM, to referees to handle some of the FM cases. Is frankly, it gives you some of the advantages to the litigants is it gives you date certain and control over your schedule and control over how it's done, which is one of the reasons why referees are often used in some of the bigger divorce cases, as I say. But when the parties have to pay the referee, a lot of our folks can't afford to do that. So we're hoping to maybe come up with a project that will help alleviate that.
Understood. Angela, over to you for questions that you might have received.
I received a couple of questions by email while we've been talking. One of them you somewhat addressed, but because you said that you highly encourage your judges to conduct these things remotely, but the question was, are the remote provisions of the new AO optional? Because this person has been encountering courts that are not following, and it makes for a very disjointed system that is frustrating to the practitioners.
They are supposed to follow it. That's the purpose of an administrative order, as opposed to inward. As I say, we have some inward looking protocols in terms of how to handle times of high transmission, which is separate. That's not orders, if you will. It's how we have asked people to handle things. But the administrative order is indeed an order. And the point of that is that it is binding on counsel parties and the court alike. So if there's a problem having that enforced, you may want to take that up with even the trial chiefs of that court or something like that. That shouldn't happen. And it sometimes there's always a little bit of growing pains, in fairness, on both sides, but.
Yeah. The second question was, please, can we overhaul Rule 12B3 of the main rules of Unified Criminal Procedure to allow constitutional claims to be protected and discovery to be litigated? There's only a 1-day window for this disposition.
For the I assume the person's referring to when things have to be filed. I mean, if anybody has a request to overhaul a rule, you can and should discuss that with the appropriate rules committee. All of the rules committees are listed on the court website together with who the chairs are of those committees. And one of the things we've started doing is, in addition to the formal large committees, if you will, standing committees, like the Criminal Rules Committee, I've also started doing all appointments, even to temporary commissions and working groups established by the legislature by means of order, so that you can find out who representatives are to any of these things. But if there's a recommendation for a change in the criminal rules, that should be addressed to the Criminal Rules Committee to consider. As I said, I've certainly had an ongoing discussion with the liaison about talking long-term what we want to do with some of those procedures in the criminal arena.
Chief, do you know if the federal court is experiencing similar issues, and if so, if there's something we can learn from that, and if we're looking at success in other state courts?
There certainly are some. If you're talking about, are you talking about responding to COVID in general or in criminal arena? COVID in general, probably.
I think probably generally, yeah, because it doesn't specifically state, but.
So the federal court, of course, locally, we were in essentially lockstep in terms of what our rules were for outside. They actually thought they would start with civil jury before criminal jury because it's easier. It takes less resources. We obviously thought that the fact that people are incarcerated with liberty at stake and had been incarcerated for years was frankly needed to be the more primary moving factor. Obviously, you know that their dockets are way smaller than ours. So it presents a very different situation. Different states have done different things. Some states have done a lot of more remote proceedings. In Texas, they were even driving iPads out to people. We don't have, I don't know how much money we have to be buying a whole lot of iPads for people to use. So there are different things that states have tried. In talking with other chief justices and in looking at what's going on in other states, I don't think anybody has a magic bullet, I guess is what I would say. People have tried different things, but I don't know that any state's in better shape, shall we say. So I don't think anyone really has a magic bullet. Are there other questions anybody would like to?
I'll pass along that in chat, we're seeing enthusiasm for the idea about referees being paid by the court, and a question for what kind of time frame we would be looking at if we go forward with that.
Fast.
Like when that would be available. Fast.
Fairly, I mean, fast in terms of how, in terms of when you think of courts moving, we only move so fast, but we've already really talked about it and how to go about doing that.
Okay, and then the final question I have, an anonymous question is, and I think this is really a question for the Rules Committee, but it's an interesting one which I'll raise, which is the court considering changing the time, the rules around the time it takes to receive things by mail, given the fact that there have been changes with the Postal Service? So an interesting thought, and let me anticipate your answer by suggesting that sounds like a good question for the Rules Committee.
Well, it is, but I will say it does touch on another issue, which is I know that people were very enthusiastic about being able to file things by email. And then we took that away from you and everybody accused us of being Luddites. But it was, again, burdening the clerk's offices in unanticipated ways, including the fact that apparently nobody trusts their email. So every time somebody filed something by email, they then emailed the clerk to say, did you receive my email? Et cetera, et cetera. So it really was unsustainable. We have, you know, as in so many areas, our clerks of court have worked so hard from day one of this pandemic and have had to be nimble and change. And people are stressed and emotions are frayed. And, you know, we can only put so much on them. Having said that, I mean, obviously one of the reasons for doing that is it's helpful with the delays in Postal Service. We are actually looking at some alternative ways of maybe doing that, so that, and it may start in the criminal arena, but I expect a report back actually momentarily on some technological ways of perhaps doing that, so that filing electronically will be more for the clerk staff, more like opening the mail, as opposed to having to be constantly overwhelmed by emails and everybody expecting a response instantaneously. And that if I file an email now, that's good enough for something that happens in 5 minutes in the courtroom. You know, all these expectations that seem to happen. So we are actually looking at a way. Obviously, we have the case management and e-filing still being piloted in Bangor, and that also is going to you know, address some of those concerns. However, that may be a ways away still from being statewide on all dockets. And so we are in the meantime looking at some other potential technological solutions for how to deal with that. And I understand that it's really exacerbated by the US mail situation. So.
And I'll just finish with one last question for you on that subject. The last we heard from Justice Mead in his role as acting chief was that the rollout of that new e-filing program was that they had received a lot of feedback, shall we say, and that it felt like there was a fair bit of work still to be done before it could be rolled out more broadly across the state, and that the time frame for that was indefinite. Is that about where we are today?
Yeah, we have made progress in some of the troubleshooting, et cetera. But it is still a bit indefinite. I mean, we obviously have made the decision that we want to get things working as well as we can in the limited arena that we're using it before we try to roll it out to other places and other dockets. But we're taking steps. Things have not been going the way we had hoped. We're taking steps to try to assess and be on track. So.
All right. Well, Chief Justice Stanfill, on behalf of the Maine State Bar Association, thank you so much. You've been so generous with your time. We really appreciate all of this information and all of these updates. It's hugely important to us. So again, thank you so much for being here today.
Well, thank you for having me. And I really hope that next time it can be in person at one of the conferences or something like that. I'm getting a little tired of sitting in my chambers here in Augusta and, looking at the Brady Bunch. So. Exactly.
Well, I think we all share that hope. It is 11:47. I'm going to take about 3 minutes and fly through the rest of these updates for you. Listen to me, I'm a lawyer. Never believe it if I say it's only going to take 3 minutes. So from the executive and judicial branch, we've already talked about this new administrative order, JB 2105, that governs remote court proceedings. And I appreciate kind of some of the additional information we got on that today. Here is the email address for you in the running for world's longest email address. And please do send your ideas in there. We just actually received an update by email on this next point, which has to do with registering your phone when you're calling clients who are inmates. And apparently you need to register your phone in a certain way to avoid your phone call being recorded. Speaking of gatherings, we have planned the Winter Bar Conference that's set for January 26th to 28th here in Portland at the Westin. This was actually a hugely successful event last year. We held it completely remotely, unfortunately. This year, we are hoping to hold it in person. We are also hoping to we are offering a hybrid alternative. So if you are unable to drive to Portland, or if you just want to attend some of the events, or if you are not comfortable attending in person, there is going to be an opportunity for you to fully participate in the Winter Bar Conference. Hopefully, we will also have an in-person aspect to it as well. Like everything else, stay tuned on that. We've also set the dates for the Summer Bar Conference. Angela, and I can't remember what they are off the top of my head. Do you? I'm putting you on the spot. It's in the summer, okay? It's in the summer. So just mark off the summer and you'll be good.
It's not as late in June as normal because of the availability. So it's a little bit earlier in June. And I'll have to figure out those dates for next time.
Stay tuned. We'll put it on the slide next time. And next time is November 10th. And that's all we have on the slide if you want to kill that off, Angela. Folks, that's all we have for Bar Talk today. I really appreciate you taking the time to tune in. I hope it was useful. If you have thoughts or suggestions for future Bar Talks, send them our way. Thank you so much. Have a wonderful day.